All right, it's 10 o'clock, so we're going to go ahead and get started, making sure I'm not on mute. All right, we're going to go ahead and get started with our second session this morning. So that's going to be mitigating the harms and reaping the benefits, the importance of effective pre-petition advocacy and navigating hidden foster care. I'm very excited about this excellent session. We have three presenters with us for this session this morning, all from Legal Aid Chicago. So that's going to be Delaney Gielow, Senior Staff Attorney, Melissa Staas, supervisory attorney, and Leah Yaris, also staff attorney. And again, that's all with Legal Aid Chicago. And with that, I am going to turn it over to you all.
Thank you so much, Emily. I'm going to share my screen. Is that working? Okay. So as Emily said, I am Delaney Gielow. I'm here with my colleagues, Leah and Melissa. We are from Legal Aid Chicago, and our presentation today is focused on the importance of effective pre-petition advocacy in navigating hidden foster care. Before we dive in, I just want to give a little bit of background on Legal Aid Chicago. We are Illinois' largest provider of free civil legal services to people living in poverty. We have about 250 employees across 7 different practice groups. We're funded by LSC, but also by private giving and various government grants. We do not receive Title IV funds. Clients typically access our services through calling our intake hotline or going on our website. We also have various direct referral relationships with providers around the county. We do not have any sort of direct referral relationship with our Title IV agency, which is DCFS in Illinois. Our family defense team at Legal Aid Chicago is small but mighty. We have 7 attorneys, and we primarily represent parents and caregivers. And I would say our work typically falls into one of 3 buckets. We do a lot of pre-petition representation for parents during open DCFS investigations. Obviously, that's the focus of our presentation today, but we also do a lot of indicated report appeals, trying to get wrongful indicated findings of abuse or neglect expunged from the child abuse registry. And then we do some post-petition representation in juvenile court. We are not the institutional provider in Cook County. The public defender's office is appointed counsel for most parents, but we do take a handful of post-petition cases. And I would say we tend to do it on behalf of survivors of domestic violence when children are removed into care for reasons related to that domestic violence. We are also able to handle ancillary civil legal issues that arise on behalf of our family defense clients. So if someone needs a divorce or is having a custody dispute, needs an order of protection, guardianship, ed-law issues, we are able to handle those. And because we have so many different practice groups and practice in a wide variety of areas, we're able to refer internally for like public benefits issues, housing, immigration, which is a huge benefit to working at a LSC provider. Before we dive in, I just kind of want to set the table for how we approach this work and some of the premises that underlie our approach. So first, and it maybe goes without saying, that the system is way too quick to separate families, and family separation is harmful and should be minimized. Juvenile court does provide some guardrails, right? Parents get an appointed attorney, there is some court oversight, mandate for reasonable efforts and reunification services, but juvenile court also destroys families, and sometimes that disruption is permanent. So if you can avoid it, you should. And so in light of all of that, our view is that effective advocacy in this space entails empowering parents to make informed decisions about what happens to their families to the maximum extent possible. Often that means fighting hidden foster care, which we'll get into, but it doesn't always mean that. And so the point of this presentation is sort of tease out the nuances and complications that arise there. All right, kicking it over to Melissa.
So just to give, we're going to give a little description of what hidden foster care is, and then we're going to describe some of the ways in which hidden foster care has come up in our own practice and give some examples of the advocacy strategies we've taken in those cases. So we know foster care is when the Child Protection Agency is putting kids in out-of-home placement after a petition has been filed in court. And as Delaney just said, there is some bare minimum of judicial oversight. In most jurisdictions, parents are entitled to legal counsel. There are evidentiary proceedings of, varying quality, and there's some degree of built-in due process, although it is by far not a perfect system. Hidden foster care removes all of those even bare minimum appearances of due process. And it's when children are separated from parents without a case being filed in the dependency or abuse and neglect division, either because it's not been filed yet or because it's never going to be filed. And the agency is going to put a family in a situation of hidden foster care, close the investigation, and sort of leave the family in disarray. And we often refer to these as extrajudicial placements. They are exacted during an investigation when parents are very vulnerable, and they are almost always implemented through threats by the Child Protection Agency. And that threat comes in the form of either you have to have your kids go live with your sister or with their grandmother or with the other parent. And if you don't do that, we'll place them in foster care. So hidden foster care can range in terms of the type of form that it takes. It can be an oral directive. It can be often what we see as a written safety plan. In Illinois, it's called a safety plan. In other jurisdictions, it might be called something else. Or it can be some form of guardianship. For safety plans in Illinois, the form that a parent signs states that they're signing it by agreement. And this is often a legal fiction because a parent is usually only signing it under duress because they're being told if they don't sign it, the agency is going to take their kids into protective custody and the parent will lose all control over where their kids might be placed. There's also what we've seen in our cases, increasing pressure by the child protection investigators for parents to enter into guardianships, private guardianships with a family member, either short-term guardianship or in-court guardianship. This is another form of hidden foster care because the parent still does not have a right to counsel. There's no built-in requirement by the agency to provide reunification services. And then there's also no support for the alternative care provider, the person who is taking guardianship of the kids. We also see hidden foster care being implemented through the form of orders of protection, either requiring our client to go get an order of protection, cutting off contact with the other parent, or our clients have sometimes been respondents in orders of protection that DCF, the Child Protection Agency, has required the other parent to get, or some other court action. And then it can also be unilateral oral directives. We certainly see cases where DCFS, the investigator, is instructing our client, you must do this, and there's not ever any paperwork exchanged. And of course, that is probably the situation that raises the most alarm bells in terms of a parent making an informed decision. This is an example of what a safety plan form looks like in Illinois. And on the left-hand side is a document called Rights and Responsibilities for Parents and Guardians. And I will say that the creation of this document about 7 years ago, and it was implemented during the course and as a direct result of a series of Section 1983 cases that had been filed through Diane Redleaf's organization at the time, Family Defense Center. We had filed lawsuit for a few cases involving safety plans, and as part of the settlement of those lawsuits, we were able to get rights and responsibilities that put, at least in writing, I mean, DCFS is free to change this at any time. So far, they haven't, knock on wood, but put in writing some of the guardrails and standards that we had been able to establish through the discovery and depositions in the case. So in Illinois, we do have in writing that a parent should only be asked to sign a safety plan if DCFS has grounds to take protective custody. But as we'll talk about in a moment, that's often not the reality. I think it's important to note that because of the inherent disproportionality in the child welfare system, hidden foster care has a greater detrimental impact on Black families. And in Illinois, the data shows that the disproportionality for families subjected to safety plans is increased beyond just there's a disproportionality that happens with the hotline call, and then that racial disproportionality index grows for families subjected to safety plans. So there is a growing disproportionality that happens, and it really does exploit the Black community's ethic and culture and tradition of communal caregiving, because there's going to be a willingness for parents and family members to step in and help out, and that does get taken advantage of. And then, but conversely, there's no resources for parents to reunify after a safety plan has been implemented, no framework for reunification, and often a family is left having been completely disorganized and rearranged with no continuing assistance. So there is a question of, are safety plans legal? And we could do a whole session just on the constitutionality of safety plans, but just to give a very sort of quick and dirty framework, in the, and I'm going to speak specifically about Seventh Circuit jurisprudence. There was a sort of a notorious decision in 2006 from the Seventh Circuit Judge Posner in Dupuy versus Samuels. It had been a class action. This stage of the litigation had been a class action on behalf of parents and families subjected to safety plans, and it was challenging the inherent voluntariness of safety plans and saying, look, these safety plans are not voluntary because they are only obtained under duress when the agency is making a threat. And Judge Posner wrote a widely derided decision, rightly so, in which he said, well, I don't understand why you're complaining about a parent getting more choices. It's like getting a plea deal when you've been charged with a crime. Of course, when you've been charged with a crime, there's been a finding of probable cause by a judge. Not so with safety plans, but okay, thank you, Judge Posner. And he summed this up by saying, having the choice of a safety plan or foster care is like being given the choice of a martini or a Manhattan at a cocktail party. It's a very just callous, cynical language that completely ignores the realities and the emotional choices that are at stake in these cases. But it did leave open a window of opportunity for challenging the legality of safety plans, because his opinion does state when an agency actually has legal grounds to take protective custody, then the choice of a safety plan is a reasonable one for the agency to be offering. And a parent choosing to take that, to opt into that arrangement is voluntary because the threat is well-grounded. And we were able to take that window and utilize it in later litigation on behalf of the Hernandez family, where DCFS did not have legal grounds to maintain the child in protective custody. And while they had the child in protective custody, they said to the parents, okay, we will release him, but only if you sign a safety plan. And the Seventh Circuit said, no, 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 that is not voluntary. That is coercive. And when there is coercion, a safety plan is not voluntary, and therefore it is not lawful, and there must be some due process in order to continue a safety plan. Right now, there is no framework for due process for safety plans, not in Illinois, and I'm not aware of there being any sort of system in another jurisdiction. So that means that safety plans that are exacted through coercion are inherently unlawful, and there could be constitutional remedies out there. So I think I'm going to pass it off. Oh, just one more. So this is my final slide. So in theory, in order for safety plans or hidden foster care to be aligned with constitutional requirements, the agency should have to have grounds to take protective custody before even making the hidden foster care demand. The parent's choice to enter into a safety plan should be completely voluntary. And that means they should be involved in establishing the terms, and it should be in writing, time limited, reviewed regularly, and the parent should have a right to legal counsel during this process. But in practice, a parent rarely has an attorney, the safety plan is being imposed based on the second, third, fourth hearsay statements made in the hotline call. And as we're going to talk about in a moment, sometimes the taking of protective custody is a bluff, but sometimes it isn't. And so we're going to talk about what we do in those cases too.
So just to summarize, there's numerous pitfalls with hidden foster care. Obviously, lack of due process. More specifically, parents don't have an appointed attorney. There's no court oversight, no reunification services, no subsidy for kinship caregivers. We don't have a lot of data about what's going on with these families, and there's a lack of accountability for the agency. But from the agency's perspective, these are actually features, not bugs, of the process. The agency has an incentive to kind of rearrange the family, deem the child safe, and close the case out without doing any heavy lifting, such as providing enough evidence to screen the case into juvenile court. So what we see a lot of times is DCFS rubber stamping that a child is safe, closing an investigation, and leaving a family in disarray.
One case that recently came through our intake that really aptly illustrates the agency's tendency to push uncounseled parents into hidden foster care processes in situations where the agency lacks any sufficient legal basis to screen the case into court, involved a dad that I'm going to call Jeffrey. Nutshell version is that Jeffrey and his son were living in a house that lacked essential utility services. So that triggered a hotline call. And in Illinois, poverty-related utility shutoffs are not a basis for taking protective custody. And in fact, in Illinois, there is an affirmative obligation that the agency has for poverty-related issues, such as utilities shutoffs, to provide hard assistance, such as paying utility arrears, or providing rental and housing assistance if it turns out the family needs to move. But in Jeffrey's case, rather than offering him the assistance his family should have been entitled to, the investigator threatened to take his son into foster care unless he agreed to a safety plan placing his son with a relative. So Jeffrey had no basis to know that that wasn't like a legally grounded threat. So he agreed to the safety plan. And when he was unable to locate a new place to stay with his son by the arbitrary deadline that DCFS had given him, the investigator presented him with a short-term guardianship agreement and told him he had to sign it for a period of 1 year, or they would take his child into foster care. I assume many states have it's not a court-ordered guardianship. It is a form agreement, basically, that if someone has witnessed it, the parents sign it and two witnesses sign it, and it has the legal effect of a guardianship, and DCFS tends to use them in cases like this, and they don't advise parents of their right to terminate the guardianship at any point. They leave parents with the impression that this is like a permanent year-long thing that they have signed and cannot undo. So unfortunately, by the time Jeffrey reached out to our office, the short-term guardianship had been signed. DCFS was on the verge of closing out this investigation. They had deemed this child safe in the relative's care. They were indicating Jeffrey, finding him guilty of environmental neglect, and they were closing out his case, basically washing their hands of this family. They felt they had no further obligation to him. Had Jeffrey contacted us earlier, we would have been better able to advise him through the process. We likely would have advised him to refuse to execute that short-term guardianship in light of the fact that DCFS did not have basis to take protective custody. And we could have held DCFS accountable for providing this housing assistance that it should have provided him in the first instance, but didn't.
Another example of the pitfalls of hidden foster care is a client I will call Michaela. So Michaela had agreed that her daughter June's father would care for June while Michaela was psychiatrically hospitalized. DCFS opened an investigation, very quickly deemed June safe with June's father. and closed out the investigation while Michaela was still in the hospital. Now, months later, Michaela fled abuse from June's father and had to leave June behind. Now, DCFS was still involved with the family because they were providing intact services, and a new investigation had opened into another family member. And DCFS acknowledged multiple times to us that they no longer had any legal authority to prevent Michaela from picking up June from the father's house, but they repeatedly threatened to screen the case into juvenile court if Michaela did do so. Michaela came to us. We were able to really pin down DCFS on what the allegations were and what evidence we had. And we helped Michaela make the assessment that we didn't think that DCFS's threat was credible. We thought they might be bluffing. We helped her put her daughter on her emergency order of protection, which allowed the police to go effectuate the transfer of June to Michaela. And DCFS did not end up screening the case, but had Michaela not had legal representation during this whole process, June would likely still be with her father right now. So as you can see, there are some strategies that we typically tend to use when we're combating hidden foster care. Our first go-to is to try to negotiate with the investigator, whether it be to terminate the safety plan or for less restrictive terms of the safety plan. Oftentimes, though, we end up having to go up the chain to agency lawyers to reach someone who actually understands that what DCFS is doing is not lawful. The other things that we can really help clients with is pinning down investigators on the evidence and allegations that they do have, so we can help clients make an informed assessment of the real risk of the case being screened in. Another thing that we do see often is just the presence of an attorney in these conversations can really cause DCFS to back off and stop making such aggressive threats to clients, which can help clients really figure out the best option for their family without these coercive threats.
So as you can see, we tend to be rightly very skeptical of hidden foster care and DCFS's attempts to use it. But with all that being said, we as pre-petition attorneys do not always fight hidden foster care, and our approach and our recommendations to clients very much vary on a case-by-case basis. So I want to spend a little time unpacking when and under what circumstances hidden foster care might actually be the least harmful option available to a client. We've tried to distill like 4 essential criteria that we feel must be present before we feel comfortable advising a client to consent or opt into a hidden foster care process. There are probably more than 4. These are just what we came up with. First, that DCFS in our assessment likely has sufficient grounds to take protective custody of the child, that they are not bluffing. Second, that there is some sort of viable alternative care arrangement to propose. So usually a relative or fictive kin who is supportive of the parent and willing to step in a pinch. Third, the client prefers that alternative care arrangement to the risk of juvenile court and is like well counseled about what that risk is. And then fourth, this most importantly, that the parent has pre-petition counsel who is able to provide the parent with a meaningful risk assessment so they can make an informed choice. And also ideally that this pre-petition counsel can follow the case and potentially assist down the line in undoing the hidden foster care intervention when it's appropriate and safe to do so. So in those scenarios where those criteria are met, affirmatively opting into hidden foster care processes can head off the possibility of a juvenile court filing and allow a parent to retain agency that they would otherwise lose. So a recent example that I think illustrates this dynamic, we had a client, I'm going to call her Jill. She experienced a tragic stillbirth medical emergency, and initially the case was investigated by law enforcement and by DCFS as a possible infanticide. And the mood among DCFS investigators was very much that this woman had murdered a baby. And so things were very fast moving and tense, and DCFS was treating it as a very high priority case. Early on in the investigation, DCFS told Jill that it would take protective custody of her toddler, who was not at all involved in the medical emergency, unless she agreed to appoint her mom, grandma, as guardian through a private probate court case. And after consulting with us, we recommended that she agree to do this. In our assessment, we thought there was a realistic possibility that a petition based on these facts would be screened into juvenile court, would be accepted by the state's attorney's office, and rubber stamped by a judge, even though at that point, like, there had been no official determination made as to the cause of the medical emergency, the stillbirth. And the other big factor was that Jill had a positive relationship with her mom. She trusted her mom not to cut off contact with her toddler, and so felt comfortable agreeing to this probate court guardianship. The DCFS investigation, after a couple of months, was unfounded after a medical examiner ruled in an autopsy report that this was a stillbirth, not an infanticide. And so now, because we continue to represent Jill as her pre-petition counsel, we're in the process of helping her get that court-ordered guardianship discharged so she can go back to the status quo that existed prior to DCFS getting involved with her family.
Another case example that illustrates advocating for a less restrictive safety plan is a client I'll call Meredith. So Meredith had always been the primary caregiver of her son, Sam. She allowed Sam to go to his dad's for parenting time. And while Sam was with his dad called DCFS with allegations that Meredith had been abusing Sam. Now, instead of implementing a safety plan or even telling Meredith anything about what was going on, DCFS helped Sam's father get an ex parte emergency order of protection against Meredith, which cut off all contact between Meredith and Sam. Now, we got into the case. We represented Meredith in the order of protection proceedings. We got that emergency order vacated, which then allowed us to advocate with DCFS for a less restrictive safety plan that Meredith was more comfortable with, because she did not trust Sam being with his father. We believed the father was coaching Sam on making up these allegations. DCFS moved Sam to a godfather's house, and that allowed Meredith to go visit him under the godfather's supervision, which was a much better situation than the emergency order of protection, which completely cut off her contact with her child.
So I'm going to wrap up because we have some time for questions if there are some, but the upshot of all of this is that pre-petition representation is the critical difference maker here. Without it, it is, we think, impossible for any hidden foster care intervention to be voluntary and therefore legal. The benefits of legal representation during an investigation are numerous and go to both sides of the equation, both the parent and the agency. First, legal representation facilitates more informed decision-making by parents by allowing them to review and make decisions based on objective evidence or information that DCFS has gathered in light of the relevant legal standards. You need a lawyer to be able to make that type of considered assessment. Second, pre-petition legal representation reduces harmful separations. It fosters agency accountability and reduces unlawful coercion by the agency and by investigators who may not be well versed in the legalities that perhaps the lawyers higher up the chain would want them to be. So this is in the agency's interest for a parent to be counseled. Fourth, counsel empowers parents to assert their rights during an investigation. It avoids the needless escalation or needless hostilities between a parent and an investigator. And finally, Pre-petition representation opens the door to creative problem solving outside the court system in the situations where it's appropriate and would reduce the overall harm of the family regulation system. So that is our spiel. We are happy to answer any questions if there are some.
Excellent. Thank you guys so much. And we do have some questions coming in, so I'm going to bounce around a little bit here, but I'm going to try to get them all addressed. So one of them was kind of generally, would you all consider kinship without payment and without findings to also be equal to what you guys are referring to as hidden foster care? And a follow-up on that was, does your agency provide Miranda warnings prior to involvement?
So I'll answer the second question first. We do not have any Miranda style warnings. I know that there was legislation in Texas that just recently went into effect regarding Miranda style warnings. There is a bill that was introduced here in Illinois recently. I don't know that it's going to go anywhere. So it's certainly something that the family defense advocates have been discussing is needed in Illinois, but it's not something that we have or that is implemented in any way, shape, or form. In terms of your question about would kinship without payment and without findings be equal to hidden foster care, I think the key for what's hidden foster care is that it is done outside the dependency or abuse neglect court division. So there is no petition that has been filed asking the court to give the 4E agency authority over the placement of kids. If there has been that petition filed, then it's more just like foster care, even if the kid isn't receiving payments, or if there's been some due process breakdown in the court system, I think that's still within actual foster care. And I'd also note the term hidden foster care was coined by law professor Josh Gupta Kagan, who I think is on the presentation or watching today. In his excellent law journal article that was published in Stanford Law Review in 2020, I think, and maybe we can include that when we send out the PowerPoints, include that article by Josh, because it really does an excellent job of illustrating all of the things that we had been seeing in practice for years and years, and identifying the real root problems with this construct of hidden foster care.
Thank you so much for that explanation. Another question that's come in, so kind of generally, one of the first ones was, how do your clients find you all?
Usually they call our intake hotline, but we also receive, like on an expedited basis, referrals from therapists, school providers, medical providers, and then sometimes there are some DCFS investigators who are familiar with us who will feel sorry for a parent and give them our number. So they call us directly that way, but usually it's just through our standard intake process.
Excellent. So that's why
And in
that
addition to
relationship
that,
building is so important, right?
Exactly. And because we're a multi-services agency, we do get a lot of internal referrals. So we will have a client in our housing practice group where a DCFS investigation pops up. Leah has a case right now with that posture that we're evaluating, and then they refer it to our team.
And then another one on sort of generally how things operate. There was a question about kind of your experience with agency investigators talking to you. So this person was noting that in their work, they're often just sent to the agency lawyers when they try to contact investigators or people working with the department. So what has your experience been on that?
I will say it's hit or miss. Some investigators are more willing to talk than others. I tend to ask for people's supervisors and go up the chain until I find someone willing to speak with me. But also if they're sending me to the agency lawyer, I'm happy to talk to the agency lawyer as well. So I think we see a wide range of responsiveness. Sometimes investigators are thankful to have another person there trying to help them figure out what's happening in the situation. But sometimes we do get stonewalled, and that's just when you have to look for other options.
Let's see. So I'm going to bounce over to the Q&A tab now. So Kristen was saying that they see a lot of families who are badly estranged from natural support systems due to chronic substance abuse disorder. So she was wondering, what you're able to offer parents that really aren't safe for kids in those situations. Didn't know if you guys had any thoughts on that.
I mean, that's sort of like not even, having bad options, like no options. I mean, I think that is probably the toughest situation, is when we have a client who really doesn't have a support system, and where the client current circumstances are such that, it's sort of inevitable that the department's going to conclude that the client isn't the person that they can leave the child with. I mean, I think we just do the best we can to fend off protective custody, but in that sort of situation, protective custody might become an inevitability. So we try to position the client as favorably as possible for the point at which court will be filed. We are not always able to prevent the case from being filed into court. That's always our goal. But there are some situations where that's just not going to be possible, and that's probably one of those situations.
And I will say we have a good relationship with our public defender's office. So we're often able to have a client execute a release to allow us to talk to whoever the public defender is that gets appointed at the temporary custody hearing. So we can get them on the phone and sort of give them the download on all of the pre-petition advocacy we've done, any like reasonable efforts, arguments they might be able to make at temporary custody, positive information we've gathered about the client that they can highlight. So even when we aren't successful at preventing the case from getting screened, we're able to set them up to put up a fight at a temporary custody hearing if possible.
Okay, thank you. Another question that came in was asking about kind of holding the agencies to account when there are non-evidence-based removals or these like right family rearrangements. And I think you can see the question there, but of course it's hard to refund lost time, love, interactions between the child, but what's the best way to obtain some kind of accountability? Have you all had any luck in that?
I mean, that would probably be a Section 1983 lawsuit, which we haven't done directly from our team yet, although we're sort of always on the lookout for potential grounds that would support an affirmative lawsuit. I worked on several of those types of cases with Diane Redleaf, and certainly if people have cases that they, clients where they think that the separation was without any grounds and was done through an unlawful threat, I'd encourage them, they can reach out to me or to Diane Redleaf directly, and certainly that's litigation that I would encourage be pursued, and it's litigation that we're always keeping our eyes peeled for here in Illinois.
Thank you. And this is a great question. So a lot of the examples that you all addressed are looking at representation of one parent. So what happens when both parents reach out to your agency together for assistance?
Looking to see if either Delaney or Leah come off mute.
That does sometimes happen. We always have to do like a conflicts analysis. Whoever the person that called intake, mom or dad, that is sort of the person for whom the presumption of their client attaches. But if we can determine, and we vet this pretty carefully, that their interests are aligned and that there's no potential for a conflict down the road, we could, I don't know that we've done this since I've been here, but we can represent both parents, and if they can sign a conflicts waiver and consent to the joint representation. And so we'll do that in appropriate cases. But that tends not to be the posture that people come to us in. Sometimes though, we will in our post-petition cases, work collaboratively with the counsel for the other parent to the extent that the parent's interests are aligned, but they have separate counsel.
Sure. Well, thank you all so much. I want to, I think we got most of the questions. We're kind of on time, so there might be a couple of more in the chat. So if you guys get a chance on the break, if you could take a look at that. I do want to note Diane and Josh both put in a good plug there. There is a national work group looking at this hidden foster care issue. and looking at potential legislation, a lot of different issues with that. So take a look at the chat if you're interested to learn more and get involved with that group. And with that, we will go ahead into our break and we'll be returning, let's see, we will be returning at 10:50 for session 3. So thank you guys again so much. That was an excellent presentation. We appreciate it.
Thanks for having us.
Thank you.